Hello, my name is David Winch. I'm a chartered accountant and a forensic accountant with Bartfield's Forensic Accountants. And in this webinar today, we're going to do the first part of 8 questions for the court to answer. So let's have a look at the agenda. First of all, I'll outline what the 8 key questions are. Then we'll tackle question 1 and question 2. And we will leave the remaining questions to a fortnight's time. And then we'll have a little chat about how Bartfield's Forensic Accountants can help you. Okay, so the 8 key questions. When I sat down and thought about this, I thought to myself, in a confiscation, there are 3 key questions that the court has to resolve. And then I thought of a 4th, and then I thought a bit more, and I finished up with 8 key questions, which I think the court has to resolve. Now, some of those questions, the court can resolve literally in about 1 minute of court time. And some of them may take several hours or indeed several days, depending on the circumstances of the case. But the court does actually have to address all 8 of these issues before finalizing a confiscation order. So I thought it'd be useful to have a look at those 8 key questions and thereby go through the fundamentals of confiscation. So question 1, does the court have power to make a confiscation order? Obviously, I'm going to talk about that more in a minute. And also question 2, does the defendant have a criminal lifestyle? Then question 3, what is the defendant's benefit? That, of course, is one of the big and potentially more difficult questions for the court to deal with. Question 4, how much of the defendant's benefit was obtained jointly, either with a co-defendant or possibly even with somebody who's not been apprehended, but nevertheless it's benefit obtained jointly with another person. Number 5, what's the defendant's available amount? Number 6, what should the defendant be required to pay? And you may be thinking, well, that's very easy because it's the lower of the benefit or the available amount. To which I would say, well, usually, but not always. Number 7, how much time should the defendant be allowed to make payment? And number 8, finally, how long should the default sentence be? So all these things are going to feed into the confiscation order which the court is going to make. Right, does the court have power? All confiscation orders are made in the Crown Court. And indeed, you might be thinking to yourselves, if you're familiar with confiscation, David Winch has asked himself the wrong question. The question I should be asking myself is, does the court have an obligation to make a confiscation order? Well, yes, I could have put it that way, but again, there are exceptions to that. Although all confiscation orders are made in the Crown Court, it would be a serious error to think that if the defendant is convicted in the Magistrates' Court, there is not going to be any confiscation or any risk of confiscation. Because conviction in the Magistrates' Court can be followed by confiscation in the Crown Court. Confiscation does always require a conviction of the defendant. Having said always, I've got to caveat that a little bit and say where a defendant has absconded, there are circumstances, it's very rare, there are circumstances in which a confiscation order can be made against an absconded defendant before he's actually been convicted. But we're trying to keep to the mainstream here. So let's just say confiscation orders always require a conviction. In this, of course, they differ from civil recovery proceedings under Part 5 of POCA. We're talking about confiscation under Part 2 of POCA. Where one of the conditions is met, and I'm going to say in a minute what those conditions are, where one of the conditions is met, the court can proceed to confiscation of its own volition. But in practice, that is very rare. Part of the reason it's very rare is that if you get the judge saying to the prosecutor, do you wish to proceed to confiscation? The prosecutor says no, and the judge says, well, I think you should, and I'm going to order that you should, then that's going to throw the prosecutor into somewhat confusion because he's not going to have prepared all the stuff that a confiscation requires. It is very rare. Where the prosecutor asks the court to proceed to confiscation, and one of the conditions that we haven't yet described, and one of the conditions is met, the court must do so. The court is obliged to do so. It's not a question of the judge having discretion as to whether he wants to pursue confiscation or not. If one of the conditions is met and the prosecutor asks the court to proceed to confiscation, then he must do so, unless, and I'm sorry, there's always, with these things, there's always an unless, isn't there? There's always a caveat, but it's not a particularly major caveat here. If the victim or a victim has started civil compensation proceedings against the defendant, or intends to start civil compensation proceedings against the defendant, then the court's obligation to start confiscation proceedings becomes a power rather than a duty. Now, the reasoning for that, subsection 6 of section 6, the reasoning for that is that the compensation to the victim, as it were, takes priority. That is considered ultimately more important, if you like, than the confiscation of money to the state. So if confiscation would somehow get in the way of a compensation to the victim, then the court might decide not to pursue confiscation. But the reality is, the practicality is, that the court actually probably would pursue confiscation and compensation, but would tailor the confiscation order so that the compensation was paid out of it. That's another issue. But basically, if one of the conditions is met and the prosecutor asks the court to go for confiscation, then the court must do so. So what are the conditions? I've mentioned a couple of times the conditions. What are they? Well, a confiscation order can be made if the defendant is convicted of an offence in proceedings in the Crown Court. Now, notice I've not said convicted of an offence from which he obtains a benefit. I'm just saying he's convicted of an offence in proceedings in the Crown Court, and that is enough to permit the prosecutor to ask the court to proceed to confiscation. Or equally, if he's committed for sentence in the Crown Court from the Magistrates' Court, having been convicted in the Magistrates, he's committed for sentence in the Crown Court, then that is sufficient to enable the prosecutor to ask for and require the court to proceed to confiscation. I've put the up-to-date reference there, sections 14 to 20 of the Sentencing Code. That basically covers the situation where somebody is committed for sentence in the Crown Court, with which no doubt you'll be very familiar. There's one other possibility. The magistrates can commit to the Crown Court under section 70 of POCA for a confiscation order to be considered. So here, this is not a committal for sentencing, it's simply a committal for confiscation to be considered. So if any one of these conditions is met, and as you can see, they're pretty easy to meet. If any one of these conditions is met, and if the prosecutor asks the court to proceed to confiscation, then the court must do so, subject to that one caveat that we mentioned before. So, for example, if I'm convicted of getting into a fight outside a pub on a Friday night, and I'm convicted of, let's say, causing actual bodily harm, convicted in the Crown Court of that, then technically I could be subject to confiscation. The prosecutor could ask the court to go for confiscation, and away we go. In practice, of course, he's not going to, if that's the only offence, because that offence isn't one from which I will have obtained a benefit. So the confiscation order ultimately might be made in an amount of nil, which would be a complete waste of everybody's time. And in practice, the vast majority of convictions do not lead to confiscation orders. In the past, prosecutors have been somewhat open to criticism for not applying often enough for confiscation orders. But there's a lot of work involved in getting a confiscation order made, and there are limited resources of the police and prosecutors, so they are going to try and choose to do it where they think it is most relevant. Okay, so all of that is in subsections 1 to 3 of section 6 of POCA. I want to talk to you about the offence concerned. The offence concerned, it sounds a rather woolly and vague phrase, but actually it is a phrase which is defined in subsection 9 of section 6. And it's defined in this way: the offence or offences which are relied upon to satisfy one of the conditions that we've just referred to, that offence or offences are the offence or offences concerned. And that terminology does appear in various places in the confiscation legislation. And it's easy to overlook the precise meaning of it, but it does have this precise definition. So you'll see that the offence concerned mentioned in section 10, which deals with the criminal lifestyle assumptions, section 75, which deals with whether the defendant has or does not have a criminal lifestyle, section 76, which deals with the benefit of criminal conduct, and section 77 that deals with tainted gifts. Each of these sections refers to the offence concerned, and we need to remember what that is, and that's the offences that we've mentioned that meet that condition. The legislation suggests that confiscation should be dealt with before sentencing. And perhaps when the legislation was first dreamt up and enacted, confiscation was viewed as going to be something that was fairly simple and straightforward, and the judge could just say, yep, benefits this, confiscation order for that, and I'll sentence you to 12 months. But in practice, it doesn't work out like that. Things get a lot more complicated and a lot more interesting. So what can we do if we can't make the confiscation order before sentencing the defendant? Well, the legislation provides that there may be a postponement for up to 2 years from conviction. And it also provides that if the court finds exceptional circumstances, that 2 years can be extended, and there's no limit on how long it can be extended. And we've seen cases over the years where the courts have found it pretty easy, frankly, to find exceptional circumstances, because, let's say, everybody's too busy to get around to it, and has extended the period. But the courts deal with that requirement as if it means that the confiscation order has to be made within that 2-year period, or longer if there's exceptional circumstances. So they've interpreted that as being that the confiscation proceedings have, if you like, to be concluded within that period. Now, I think it's arguable, and certainly the Law Commission seem to have taken that view, this view in their recent consultation. It's arguable that actually what is required is that the confiscation proceedings should be commenced, not concluded, commenced within that 2-year period. And typically the court will, before sentencing, either set up a timetable for Section 18 order to be made, or make the Section 18 order, which is the order that requires the defendant to produce information, and set up a timetable for Section 16 statement to be issued, which is the prosecutor's statement in which he spells out what he believes the defendant's benefit is and his available amount. And simply setting that in motion may be sufficient to remove any potential problem with the 2-year time limit. So that's a slightly different interpretation the Law Commission has come up with to one that courts have typically taken over the past few years. But the legislation does indicate that during a period of postponement, there are various things that the court must not do. The court must not impose a fine, a surcharge, an order for compensation, or a forfeiture or deprivation order. And I suppose the logic of this is that if the court, let's say, fines the defendant, then that is going to impact on his available amount for confiscation. That's going to muddy the pool in confiscation. So the court is required not to do any of these, if you like, financial things. It can certainly send him to prison, but it's required not to do these sort of financial things before making the confiscation order. Now, forfeiture has caused a little bit of a problem, because suppose the defendant has been caught with a bag full of cocaine, then the trial judge might well want to order the forfeiture and destruction of those drugs. And to delay and delay and delay making that order until after the confiscation is sorted out seems a bit silly. But that seems to be the way that the legislation certainly has been interpreted. And then the questions have arisen sometimes where there has been, if you like, a forfeiture and destruction of drugs. Does that mean the court then is no longer able to go on and make a confiscation order? Well, case law says that, in fact, no, the court can actually move on and make a valid confiscation order. There's a case there in the slides which gives more details of that. But the logic of it is that if the defendant is actually not disadvantaged, doesn't suffer an injustice by that having been done technically not correctly, then the courts shouldn't be prevented from going ahead and making the confiscation order. Okay, so that kind of covers question one. When can the court make a confiscation order? When does it have power to do so? And as you'll see, it has power to do so in a wide variety of situations in which it is not actually likely to use that power. So, question two, does the defendant have a criminal lifestyle? Now, you might be surprised that I'm addressing that question before asking what's the defendant's benefit. And there's a little bit of to and fro here in that, as you will see, in part, to decide if the defendant has a criminal lifestyle, we might actually also have to decide what his benefit is, or decide something about his benefit. So the two questions are kind of intertwined. But criminal lifestyle has nothing to do with the defendant's lifestyle. It is determined solely by the defendant's convictions and also offences taken into consideration in sentencing, if there's any of them. But principally, it's about the defendant's convictions, not about his lifestyle. There are four separate routes to a criminal lifestyle, and we'll go through each of them. Route one, where the defendant has been convicted of an offence listed in Schedule 2, or more than one possibly, whether or not he has obtained any benefit from that offence, then he has a criminal lifestyle. So if we take an example, suppose myself and my brother decide that we're going to go to continental Europe to buy some cocaine and import it back to the UK. So off we go, we get on Eurostar, we go to Europe, we ask about if anybody's got any cocaine they want to sell us, and sadly no, and we come back empty-handed. We have obtained no benefit. But have we committed an offence? Well, certainly yes. We have committed an offence of conspiracy to import cocaine into the UK. So assuming we're convicted of that, that's a Schedule 2 offence. Even though there is no benefit at all, we go straight in to confiscation with a criminal lifestyle. The Schedule 2 offences include most drugs offences, one exception being the cultivation of cannabis, contrary to Section 6 of the Misuse of Drugs Act. The production of cannabis, contrary to Section 4, is a criminal lifestyle offence. So what you find in practice is that cultivation is not often charged, that the conduct is instead charged as production under Section 4, which is a criminal lifestyle offence. But if you come across a Section 6 conviction, then no criminal lifestyle from that, or at least no Schedule 2. Money laundering offences under Sections 327 and 328 are criminal lifestyle offences. So that's conceal, disguise, remove, transfer criminal property, entering into an arrangement to facilitate the criminal property. Again, those are criminal lifestyle offences. Section 329 offences, possession, use and acquisition of criminal property, are not Schedule 2 offences. Some trademark and copyright and counterfeiting offences are Schedule 2 offences, and there are various other offences listed in the schedule. One to watch out for under the Sexual Offences Act, there's a new Section 33A, I think it is, offence. That's not in Schedule 2, to do with prostitution. Section 33 offences are, Section 34 offences are, Section 33A offences are not. So they're not Schedule 2 offences. So that's route one. If you've been convicted of one of these offences, whether you've obtained any benefit or not, you have a criminal lifestyle, and that's the end of that. And conspiracy and attempt and so on in relation to a Schedule 2 offence, they are also Schedule 2 offences. Route 2. It's going to get a little bit more complicated now, sorry. If the defendant has been convicted of an offence committed over a period of at least 6 months, from which he has obtained a benefit of at least £5,000, then he has a criminal lifestyle. So this is a single offence committed over at least 6 months, from which he's obtained a benefit of at least £5,000. For example, Social Security benefit fraud offence continued over a period of at least 6 months and resulting in a benefit of at least £5,000. Bang, criminal lifestyle. Tax evasion offence which has been continued over a period of at least 6 months, resulted in evasion of tax of at least £5,000. Yep, criminal lifestyle. An employee abusing his position to defraud his employer over a period of at least 6 months and obtaining a benefit of at least £5,000. Yep, criminal lifestyle. Let's imagine that Jane is employed and steals £3,000 from her employer in January and steals another £3,000 from her employer in August. If she is charged with fraud by abuse of position between January and August, then she's going to have a criminal lifestyle because it's an offence committed over a period of at least 6 months from which she's obtained £6,000. If she's charged with 2 separate offences of fraud, one for £3,000 in January and one for £3,000 in August, then she's not going to have a criminal lifestyle because she has not committed an offence or not been convicted of an offence over a period of at least 6 months. She's been convicted of 2 separate offences. So the charging can make a difference to whether a person has a criminal lifestyle. Okay, that's route 2. Route 3, the defendant has been convicted in the same proceedings of at least 4 offences, from each of which he has obtained some benefit, and the aggregate benefit obtained from these offences is at least £5,000. So if Jane, that I was talking about before, actually commits 4 different thefts on different dates and gets charged with 4 different individual thefts, and the total is at least £5,000, then she will have a criminal lifestyle. That does sometimes cause some issues because, particularly years ago, prosecutors were used to dealing with a different test which referred to 2 convictions under the Criminal Justice Act of 1988. And sometimes they've applied the wrong test. So we do need to check where there's an allegation of criminal lifestyle, that there is at least 4 offences from each of which the defendant has obtained some benefit. I did a case recently where one of the offences involving somebody driving away from a bank, one of the offences was driving while disqualified. Well, that isn't an offence from which he obtained any benefit, so that doesn't count towards the 4 offences, 4 or more. But, for example, if we've got a defendant convicted in the same proceedings of several offences of fraudulently transferring to his own bank account monies held in the account, let's say, of a vulnerable person for whom he's got a power of attorney, and the amounts transferred in respect to the offences were £250, £300, £2,000 and £2,500, that totals just over £5,000. That's 4 offences. Yes, this person is going to have a criminal lifestyle under route 3. And finally, route 4, which is the most complicated of all, I'm afraid, is where the defendant has been convicted of 1 or more offences, but has also been convicted on at least 2 previous occasions. So we're not talking about the same proceedings, we're talking about different proceedings. There has been at least 2 different proceedings in addition to the current proceedings within the period of 6 years prior to the start of the current proceedings, of offences from each of which he's obtained some benefit, and the aggregate benefit he has obtained from all these offences is at least £5,000. Have to say, it's not one I often see in practice, but that is there. So if you've got somebody, let's say, who's been convicted in 2016 of a theft of £1,000 and convicted in 2018 of a theft of £3,000 and is currently being sentenced in 2021 for a theft of £1,500 in 2019. So the proceedings for this theft must have started after those convictions in 2016 and 2018. Then we've got a total benefit of just over £5,000, and we have 2 previous convictions in that 6-year period, which ended when these proceedings started, and these proceedings will generally start when he's been charged. And so he has a criminal lifestyle. Those are the 4 routes to a criminal lifestyle. There is one point to mention about offences taken into consideration, TICs, as they are sometimes referred to. And that is this. We talked about numbers of offences, and TICs do not count towards numbers of offences, but the benefit obtained from TICs does count towards the £5,000 limit under routes 2, 3 and 4 that we've just mentioned. I have to say, I don't really see much advantage for a defendant in offering TICs, because if confiscation is on the cards, then he's just going to create more problems for himself by putting TICs up there. But there we are. Okay, Let me tell you a little bit about Bartfield's. Bartfield's Forensic Accountants remains, I'm pleased to say, fully staffed. We're undertaking legally aided and privately funded criminal and civil forensic accountancy work. Fortunately for us, it is relatively easy for us to conduct the bulk of our work remotely using our up-to-date and secure IT facilities, and we remain readily contactable by phone, email, and online video links. Our recently updated website is full of useful information, and of course that's accessible 24/7. You can find more on this topic on the website in the news section, and this and previous webinars can be found in the seminars section, where you'll find the slides and also recordings of the actual webinar. A free recording of this webinar is going to be emailed to you in the next few days. And if you have any questions, the easiest way to get hold of me, frankly, is to email me. The email address is there on your screen. Drop me a line and I will do my very best to help you in any way that I can. Thank you very much for your time. I hope you found this useful. In a fortnight, we will continue with the other key questions which the court needs to address before making a confiscation order. I hope I will see you then. Thank you and goodbye for now.